Hello everybody, I am Taniya Pandey and I welcome you to this episode of Courts This Week on LiveLaw, and I wish you a very happy and colourful Holi. It's time for our weekly update of important judgments. Let's go over the Supreme Court updates first. The Supreme Court has directed that there should be no charging of compound interest, interest on interest, or penal interest on the instalments which were due during the loan moratorium period from March 1st to August 31st, 2020 on any borrower, irrespective of the loan amount. If such interest has already been collected, it should either be refunded to the borrower or adjusted towards the next installments. Last year, the Centre had taken a decision to allow waiver of interest in 8 specified categories for loans up to Rs 2 crores. The Supreme Court observed that there is no rationale in the Centre's policy and termed it to be arbitrary and discriminatory. The court observed that compound interest is chargeable on willful or deliberate default by the borrower to pay the due installments. So, when the installments have been deferred based on the moratorium declared by the RBI, the non-payment of installments cannot be termed as willful. Therefore, there is no justification in charging compound interest, which is in the nature of a penal interest during the moratorium period, the court said. The bench of Justices Ashok Bhushan, R. Subhash Reddy and M. R. Shah also observed that the powers and functions of ministries do not get transferred to the National Disaster Management Authority in the event of a national disaster. The Supreme Court has nullified general directions issued by the Kerala High Court regarding the deletion of parties from the array of accused in the final report. The High Court is hearing a petition filed under Section 482 of CRPC against an order dismissing an application to summon 3 persons as additional accused as per Section 319 CRPC. While deciding this case, the bench of Justice Soma Rajan deliberated upon the general issue of procedure to be followed while deleting accused and held that it was incumbent upon the police to file a final report under Section 173(2) of the Code of Criminal Procedure in every case in which investigation had commenced as per Section 156 CRPC. The High Court had deprecated the practice of police filing casual reports before the magistrate to remove or delete parties from the array of accused and directed for notice to be given to the informant regarding the removal of deletion of accused. The Supreme Court held that such directions should not be taken as general and shall not be given effect to. The Supreme Court has observed that a telephonic message which does not clearly specify the offence cannot be treated as an FIR. In this case, 2 out of 3 persons accused of murder were acquitted by the trial court and 1 was convicted. The High Court confirmed the conviction of the 3rd accused and reversed acquittal of the other 2. One of the contentions of the appellants was that the initial information received was over telephone by 2 persons who made mention of an attack. However, when the FIR was actually allegedly recorded, there was an improvement in the narrative and the other accused were implicated. The Apex Court bench of Justices L. Nageshwar Rao, Hemant Gupta and S. Ravindra Bhatt considered the issue whether the initial intimation received by the police on telephone on the day of the incident constituted an FIR. The court relied on the judgments in T.T. Anthony, Damodar and Surjit Sarkar and held that a cryptic phone call without complete information or containing part information about the commission of a cognizable offence cannot always be treated as an FIR. The Supreme Court has held that in an application under Section 7 of the Insolvency and Bankruptcy Code, the applicant can claim the benefit of Section 14 of the Limitation Act in respect of proceedings under the Sarfazi Act. Section 14 of the Limitation Act allows for exclusion from the limitation period for a time spent litigating before a wrong forum. A bench of Justices Indira Banerjee and Hemant Gupta held that Section 14 applies to an application under Section 7 of IBC and that there is no rule that the exclusion of time under Section 14 is available only after the proceedings before the wrong forum terminate. The bench also held that Sarfazi proceedings are civil proceedings for the purposes of Section 14 of the Limitation Act. The court also held that there is no bar on exercise by the court or tribunal of its discretion to condone delay under Section 5 of the Limitation Act in the absence of a formal application. However, the court can always insist that an application or an affidavit showing cause for the delay be filed. The Supreme Court has deprecated the practice of making adverse remarks by high courts against judicial officers. The High Court of Karnataka, in a judgment, had made adverse remarks against a judicial officer who presided over the Motor Accidents Claims Tribunal. The Apex Court said that any criticism or observations must be judicial in nature and should not formally depart from sobriety, moderation and reserve. Setting aside the adverse remarks, the bench observed that if the High Court really thinks that there are serious aspects arising in respect of the manner of passing of the judgment by the tribunal, the High Court on the administrative side may issue a notice to the judicial officer and taking appropriate decision after giving her an opportunity to put forth her stand. The Supreme Court has observed that adjudicating authority cannot substitute any commercial terms of the resolution plan approved by the Committee of Creditors. One of the issues considered by the Apex Court was about the extent of and limitations over the powers and jurisdiction of the adjudicating authority while dealing with the resolution plan approved by the Committee of Creditors. The bench of Justices A.M. Khanvilkar, Dinesh Maheshwari and Sanjeev Khanna referred to various judgments and said that if within its limited jurisdiction the adjudicating authority finds any shortcoming in the resolution plan vis-a-vis the specified parameters, it would only send the resolution plan back to the Committee of Creditors for resubmission. The Supreme Court has observed that it is permissible to hold a discrete or open inquiry at pre-FIR registration stage in corruption cases. In this case, notice was issued to the appellant by the Police Inspector, Anti-Corruption Bureau, Nagpur, to give his statement in respect of properties owned by him for the purpose of inquiring into a complaint against him alleging corruption. The High Court dismissed the appellant's challenge to the notice. In appeal, the bench of Justices D.Y. Chandrachud and M.R. Shah considered the question whether such an inquiry at pre-FIR stage would be legal and to what extent an inquiry is permissible. Referring to the judgment in Lalita Kumari v. Government of UP, the bench held that an inquiry at pre-FIR stage is not only permissible but desirable, and if on the basis of material collected during such inquiry, it is found that the complaint is vexatious and there is no substance at all in the complaint, the FIR shall not be lodged. The bench also observed that the statements made during the inquiry at pre-FIR stage cannot be said to be a statement under Section 160 CRPC and or the statement to be recorded during the course of investigation as per the Code of Criminal Procedure and therefore cannot be used against the accused during the course of the trial. The Supreme Court has observed that potentiality of acquired land is one of the primary factors to be taken into consideration to determine market value of the land. The question whether a land has potential value or not primarily depends upon its condition, situation, use to which it is put, or its reasonable capability of being put, and also its proximity to residential, commercial or industrial areas or institutions. The bench of Justices U.U. Lalit, Hemant Gupta and Ravindra Bhatt observed, while allowing the appeals filed by Uttar Pradesh Awas Evam Vikas Parishad against enhancement of compensation by the Allahabad High Court to landowners of the acquired lands in some villages in the state. The Supreme Court, in its judgment which declared that the evaluation criteria adopted by the Indian Army to consider the grant of permanent commissions for women officers to be arbitrary and irrational, discussed the doctrine of indirect discrimination, Justice D.Y. Chandrachud, who authored the judgment, observed that the doctrine of indirect discrimination is founded on the compelling insight that discrimination can often be a function not of conscious design or malicious intent, but unconscious or implicit biases or an inability to recognize how existing structures or institutions and ways of doing things have the consequence of freezing an unjust status quo. The court observed that in order to achieve substantive equality prescribed under the Constitution, indirect discrimination, even without discriminatory intent, must be prohibited. The above observations were made after the court referred to various judgments from United States, United Kingdom, South Africa and Canada. The court noted that the doctrine of indirect discrimination has found its place in judgments like Navteej Singh Johar versus Union of India, the Sabrimala judgment in Indian Young Lawyers Association versus State of Kerala, and Joseph Shine versus Union of India. The Supreme Court has quashed the FIR registered against Shillong Times editor Patricia Mukhi over a Facebook post on violence against non-tribal people in Meghalaya. The bench of Justices L. Nageshwar Rao and S. Ravindra Bhatt noted that the Facebook post was directed against the apathy shown by the Chief Minister of Meghalaya, DGP and the Darbar Shnoong of the area in not taking any action against the culprits who attacked the non-tribal youngsters. Referring to sections 153A and 505(1)(c) of the Indian Penal Code, the bench observed that only where written or spoken words have the tendency of creating public disorder or disturbance of law and order or affecting public tranquility, does the law need to step in to prevent such an activity. The court remarked, free speech of the citizens of this country cannot be stifled by implicating them in criminal cases unless such speech has a tendency to affect public order. Let us now look at the top updates from different high courts in the country. In a judgment that lays bare the reality of redevelopment in Mumbai, the Bombay High Court has held that even the slightest delay in project completion or payment in rent is sufficient to warrant the termination of a developer's contract. A single bench of Justice Gautam Patel has observed that in matters of redevelopment, which are in the realm of private law, there is no such thing as substantial compliance. The Delhi High Court has sought response from the Broadcasting Ministry on a petition challenging its order refusing to take any action against TV9 Marathi channel for allegedly airing a homophobic show in March last year. The petitioner has alleged that in the show a guest speaker was invited who communicated during the program that homosexuality is a disease and that said program propagated harmful information about curing homosexuality. The Karnataka High Court has held that only substantive sentences and not default sentences can be made as concurrent if the transaction is a single transaction. A single bench of Justice H.P. Sandesh, while dismissing the petition, said, I would like to make it clear that default sentences cannot be made as concurrent and the same should run consecutively in respect of the substantive sentence. This court has to look into each case material before the court whether the transactions are arising out of the same transaction or different transactions. The Allahabad High Court recently granted bail to a woman accused of abducting a 19-year-old girl and forcing her to convert her religion. The woman has been charged by the UP police under the Uttar Pradesh Prohibition of Unlawful Religious Conversion Ordinance 2020. The provisions of the ordinance, which has now taken force as an act, declare unlawful religious conversion as a cognizable and non-bailable offence. The single bench of Justice Muhammad Faiz Alam Khan noted that in her statement under Section 164 CRPC, the prosecutrix had not made any imputation against the applicant and the bench found substance in releasing the applicant on bail. The Bombay High Court recently refused permission to a couple to take custody over a 2-year-old child on the strength of a notarized adoption deed. The petitioners who claim to be the child's adoptive parents approached the High Court seeking a writ of habeas corpus after the child was taken away by the Child Welfare Committee, that is CWC. They asserted that they adopted the child after 2 weeks of her birth. After examining the notarized deed, the court found that the document nowhere indicated that the requirements of the Hindu Adoption Act pertaining to a valid adoption were complied with in letter and spirit. After the court recorded a finding that the petitioners did not pursue their remedies under the Juvenile Justice Act, the court dismissed the petition. That's all for this week. I hope you enjoy the festival of Holi while still taking care of your health and safety. Happy Holi. Have a wonderful time.
Subscribe to our channel and press the bell icon to never miss a video from LiveLaw.